Hello, my name is Mark Walters. I'm a professor of law at Queen's University in Canada. I was very privileged to be the Oliver Smithies Visiting Fellow at Balliol College in Hillary and Trinity terms of this year. And I want to begin simply by thanking the Master and Fellows at Balliol for the opportunity of visiting the college, where I met a lot of wonderful people and had a productive 2 terms in terms of my own research. I should thank as well the law fellows at Balliol, Hassan Dinger, Grant Lamont, the professor of the philosophy of law, David Enoch. There's a bit of a Canadian connection between law and Balliol. David assumed the chair that Joseph Raz originally had, but more recently Les Green had. And of course, Timothy Endicott, a Canadian law fellow at Balliol until his move to All Souls recently. So this talk was originally to have been live, and unfortunately that proved to be impossible on the day, for which I apologize, but Richard Norman kindly suggested that we record the lecture so that those interested could see it. And of course, I'm delighted to do that today. The subject of the talk, Laws of Empire and Laws of Nations, Reflections on the Rule of Law in Crown-Indigenous Relations in North America, picks up on some themes that I've been working on in my research. I'm interested in the rule of law generally, both from the perspective of the common law tradition, but a strand of my research looks at relationships between Europeans and Indigenous peoples in particular in North America and in Canada. And there's a question, I think, about whether those relationships historically could have been relationships of law, whether the rule of law was something that could be part of the relationship between imperial powers and Indigenous peoples. And that's really what I'm interested in. It's an interesting question for history, for legal history, obviously. It's an interesting question as a matter of legal philosophy as well. So back to Joseph Raz, former Balliol Fellow, of course. He is famous for arguing that the rule of law could simply be a tool making as he puts it, the knife of law sharper, in which case it may be a tool of power. My own view is that the rule of law, if it matters at all, is more than that. It encompasses relationships of justice as well. Whether that's possible in certain phases of the history of the relationship between Indigenous peoples and imperial powers is a good question. It's a question of history, it's a question of theory, it's a question of law today in Canada, and I'll just refer you to this provision in the Constitution Act of 1982 in Canada, which states in Section 35 that the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. And then it defines Aboriginal peoples of Canada as including the Indian, Inuit, and Métis peoples of Canada. So as of 1982, at least, Aboriginal and treaty rights have been constitutionally protected, and that gives rise to some incredibly challenging questions of interpretation. What are Aboriginal rights and what are treaty rights? The Aboriginal peoples of Canada nowadays tend to describe themselves as Indigenous peoples. The labels shift over time in terms of how the Indigenous peoples of North America and elsewhere in the world are referred to. So treaties really will be the focus of this talk in terms of, back to the question, was there a relationship of law at all? And more specifically, I want to ask the question, were treaty relationships a way of establishing legal relationships? Now, what are treaties and what are treaty rights? It's one thing to point to a document that we can say, well, that's the treaty. And there are many documents that appear treaty-like from the European legal perspective in what became Canada. So this one is just an example. It's called Treaty Number 3. Some of these treaties were just numbered as the Crown proceeded across the country to obtain territory from Indigenous people. This is a treaty between the Crown and the Ojibwe peoples of northwestern Ontario, just northwest of Lake Superior. And the text calls itself a treaty, defining the parties, articles of a treaty made between the Queen of Great Britain and Ireland and the Saulteaux tribe of Ojibwe Indians. And then the objective is stated in the preamble, whereas the said Indians have been notified that it is the desire of Her Majesty to open up their territory for settlement, immigration, and other purposes, and to obtain the consent thereto of her Indian subjects inhabiting the said territory. So just very quickly, almost immediately, we see a question of interpretation. Is this treaty an instrument of international law? Is it as we think of treaties between nations, or something else? And it is curious, I think, that the Ojibwe peoples are referred to as Her Majesty's subjects. They're already subjects even before the treaty was made, which suggests from the Canadian/British legal perspective that this is not an international agreement. It's something more domestic in legal terms, but exactly what status it has is unclear, at least from the terms. By the way, this treaty went on to provide that the Ojibwe nation surrenders and cedes some 55,000 square miles of their territory. It's a huge territory in return for some payments. Also the right to continue using the surrendered territory until taken up for other purposes. And that clause of the treaty is still very important today. And I should say, although it's Her Majesty, the Crown, the Queen of Great Britain and Ireland, this is interpreted as a treaty binding on the government of Canada today. And I may as well mention as well, the Crown is still part of our constitutional arrangement in Canada. King Charles is the King of Canada. However, in the decades following this treaty, at least, the Crown of Canada and the Crown of the United Kingdom split, and there is no longer a legal connection between them. So nevertheless, he's still our king, and still a partner to these treaties. So it's easy enough at one level to see that as a treaty because it looks like a treaty, and it has the wording of a treaty. It's more difficult to see these as treaties. And what are these? They are indeed representations of treaty relations. They are wampum belts. They are belts woven together out of or from beads that are formed from a certain kind of shell. And so I'll be speaking a little bit more, or quite a bit more, about wampum and its role in forming relationships between Indigenous people and non-Indigenous people. And I'm going to come back to these two belts in a moment. But my point here is for non-Indigenous people who are not familiar with Indigenous traditions, legal traditions included, it's hard to know what to make of these belts. And that is true today. with lawyers and judges confronting claims that these belts still represent treaty relationships that are constitutionally protected, even though these belts were made. We're not sure how old these ones are, but they may date from the 17th century, possibly the 18th century. The use of wampum belts to form relationships was very common within the Great Lakes region of North America and the St. Lawrence River Valley. So it's an old map, but those of you familiar with the geography may recognize the 5 Great Lakes. The present-day border between Canada and the United States runs through the middle of these lakes. South of the lakes on the right-hand side, Ontario and Erie, is New York State, formerly the colony of New York, of course, and then north is the province of Ontario and Quebec. And these territories were and still are occupied or considered to be the traditional territories of a series of peoples. The set of peoples I'll be talking about mainly is the Haudenosaunee Confederacy, and but I'll also mention a different culturally and linguistically a different set of people, the Anishinaabe peoples. So very briefly, the Haudenosaunee Confederacy was called the Iroquois Confederacy by the French during the time that the French controlled Canada, or the 5 or 6 Nations is how the British referred to them. They consist of, or the Confederacy consists of, the Mohawk, Cayuga, Oneida, Onondaga, Seneca, and as of the early 18th century, Tuscarora nations. Back to wampum quickly. I mentioned that the beads are formed from shells, a particular kind of shell, the quahog shell, which is found on the northeastern coast of North America. And so these nations were further inland. They traded to obtain these shells in order to make beads. The beads were hard to make until Europeans arrived on the scene and an industry sprang up using drills that the Europeans brought to create wampum beads in a much more efficient way, and thousands and thousands and thousands of these beads were produced. Wampum served a number of different functions. At times it was a form of currency, but the importance for diplomatic relationships became evident for all Europeans dealing with Indigenous peoples in this region, which included the French in what became Canada, the British, of course, but in this particular area, the Dutch were the first to enter into relations with the Mohawk and other Haudenosaunee peoples. The beads were woven by Indigenous women who were remarkable craftspeople, and the designs are quite stunning. Sometimes they're just strings, sometimes they're elaborate belts. These are photos taken from an exhibit at the McCord Museum in Montreal. I'm not sure if the exhibit is still on, but it was an unusual collection of wampum belts. Sadly, the stories, the oral traditions behind some of these belts have been lost. We know they're treaty belts, and we don't always know when the treaty was held and what the specific relationship these belts represent. In some cases we do, but in some cases, sadly, we don't. The belts were exchanged at council fires, like this one. It's a simplistic drawing, but it kind of represents the idea of Europeans gathered with Indigenous people at a fire, and that council fire itself was a metaphor. The relationship is full of metaphors. A council fire, I think, is a place to hold a council. but it's a form of governance as well, almost a constitution, as it were. This is a photo from the late 19th century of Haudenosaunee hereditary chiefs at the Six Nations Reserve in southern Ontario, displaying the important belts that, in their view, affirm a particular constitutional status that they have with the Canadian government. Sadly, within a few decades, this hereditary system of government was overthrown by the Canadian government, and a statutorily imposed elected system, band council system, was imposed on this community. And at that time, many of these belts were simply taken away by the police. Some of them have been repatriated to the community, and others have sadly been lost. This is one of the hereditary chiefs from about the time that the hereditary system was overthrown within this particular Haudenosaunee community. His name is Diskaya, or Levi General, and his view, and the view of many Mohawk people to this day, is a strong view of sovereignty. The argument is that the belts confirm an independent status for Mohawk and other Haudenosaunee nations. And so he is holding what would often be called a covenant chain belt or a friendship belt in his hand, and on his lap is appears to be the two-row wampum belt. And these are the photos of the two belts he's holding. I'll refer back to the covenant chain belt, the top belt, later. The two-row wampum belt is perhaps more iconic and famous today, at least. And the oral tradition behind this belt is that the two rows of purple shells on the white background represent Europe. Well, one of them represents a European vessel, and the other an indigenous canoe. They are traveling on the river of life, I suppose you could say, together in tandem, but following separate paths. The three rows between the two lines represent the principles of respect, peace, and alliance. The idea, we are told, or as I understand the oral tradition from Mohawk and other peoples, is that the peoples stay within their own vessels. The vessels represent a jurisdiction, as it were. And within the vessels, the laws, customs, and traditions of each of the two sets of treaty partners remain intact. So it's a relationship of unity and friendship, but also one of respect and freedom and tolerance for the autonomy of each of the treaty partners. It's a very rough attempt to explain what is a far more complex set of ideas, I think, but that's the essence, as I understand it, of the two-row wampum. The two-row wampum and the covenant chain belts were prominent during, have been prominent on and off since the 17th century in discussions, but I refer to the Oka crisis as an example of when the tensions between Mohawk and other communities, Haudenosaunee communities, and other Indigenous communities has sadly erupted into violence in Canada. So Kanesatake is a Mohawk community just west of Montreal. The local municipality in 1990 wanted to expand a golf course into an area regarded as sacred by the Mohawk. The Mohawks established a blockade, and to prevent this from happening, the police moved in, and sadly, a police officer was killed. At that point, Mohawk warriors, heavily armed from other Mohawk communities, came into the community, and a standoff ensued. And I should say, the role of armed resistance is controversial within Mohawk and other communities. Not all of the Mohawk peoples were entirely happy with the arrival of heavily armed warriors. The provincial government in Quebec felt like it had lost control of the situation and asked for the assistance of the Canadian Armed Forces, which arrived in their thousands in their tanks. And so this is a scene that is still shocking for me today. I was a law student at the time in 1990, and it was shocking then, and it looks like a war zone. It's not something that we're used to seeing in Canada. The standoff lasted for 78 days, and eventually the cordon around the protesters were shrunk, and they surrendered in the end. But during the negotiations, the two-row wampum belt and the covenant chain belt were argued to represent the sovereignty of the Haudenosaunee peoples. Now, whether that sovereignty is, as Desquea from the 1920s insisted, a form of international sovereignty, or a more localized internal sovereignty within the Canadian state, is something that is still debated among Indigenous peoples today. So different views exist on that point. A more recent example is this case. It's a decision of the Quebec Superior Court from just about, well, less than a year ago. It's a prosecution. So yes, the king is there. His Majesty the King still prosecutes criminal cases in Canada, as he does in the United Kingdom. Whether he knows he's doing it in Canada, I don't know, but in name at least, he is prosecuting two Mohawk men, Montour and White, who are charged in this case with fraud for bringing into Canada commercial goods without paying excise taxes. And their defense is they don't have to pay taxes because they have a treaty relationship with the Crown, which protects their right to engage not only in other forms of self-governance, but trade. The Attorney Generals of Canada and Quebec are intervening to make constitutional arguments, as is the Mohawk Nation Council of Chiefs. I'm going to return to this decision in a few moments, but one reason I mention it is because I was involved in the case. The lawyers for the two accused Mohawk men asked a number of people to be expert witnesses to explain to the judge the nature of the treaty relationship. And that relationship was and is still contested. The attorneys general for Quebec and Canada argued that the covenant chain treaty relationship that I've been talking about and that the two accused rely upon was not a treaty at all. And so it's not constitutionally protected, and they have no defense, no treaty defense at least. Many judges are unfamiliar with the history behind the wampum belts, and the judge in this case, Sophie Bork, hadn't had an opportunity to judge a case like this before. Hence, the importance of having some witnesses. I'm not sure if I was the right witness. There were Indigenous witnesses who could speak in a more expert and authorized way about the legal traditions that inform the treaty relationship. So I was deferring to others and that is something I think I have to do throughout my work in this area, is to appreciate that as a non-Indigenous person, it's very difficult for me and other non-Indigenous lawyers and academics to get a full sense of the Indigenous legal perspective. And yet it is a treaty relationship. And so struggling with that challenge is an important one. So in my attempt to do my best to explain the treaty relationship to the judge, I focused on this character a lot, Sir William Johnson, who was the Crown's representative in the northern parts of British North America in the mid 18th century, Superintendent General of Indian Affairs. Now, part of the complexity of this story of this treaty relationship is at about the time or shortly after his death, there is the American Revolution, and the United States emerges as an independent sovereign state. And the British Indian Department at that point continues. In fact, the next Superintendent General was Sir John Johnson, Sir William's son. They just shipped themselves and their department north of Lake Ontario into what became Canada, and carried on. The treaty relationship carried on with those Indigenous peoples who found themselves on the Canadian side of the new border. So there's this continuity, interesting continuity from the Dutch, who originally made the treaty relationship, the British who take over from the Dutch, and then the Americans have their own history after 1783. But in Canada, we still have that crown representing the one end of the treaty relationship. I should say, yes, they moved up to Canada, and in fact, in Kingston, Ontario, the Johnson name is everywhere. Johnson Street is a few streets over, and as I look out my window, Sir William's granddaughter's house is at the corner. An interesting aside. Another thing about Sir William is he understood the Mohawk people and language and customs as well, probably as any British official did. His Indigenous wife was Molly Brant, a respected clan mother within the Mohawk community, and she eventually settled here in Kingston, Ontario. Treaty councils were held at his house in Johnson Hall in upstate New York, which is still standing. And I just now want to turn to the kinds of things that went on at these treaty councils to introduce the idea of Indigenous legal traditions and their role within the treaty relationship. So this is Sir William speaking at one of these councils in 1768. The format, the treaty is not a written treaty. All we have are the wampum belts and transcriptions of oral exchanges. But they follow a fairly standard format. So he begins by calling them his brethren, and identity as brethren or kin, or establishing a kinship relationship, was central to this relationship. And he says, on this occasion, as I would deal with all people in their own way, and as your ancestors have from the earliest times directed and recommended the observation of a set of rules which they laid down for you to follow, I do now proceed agreeable to that custom. So he kindles the council fire, and then further down, in order to prepare you the better for these purposes of doing business at the council, I do now, agreeable to the ancient custom established by our forefathers, proceed to the ceremony of condolence, usual on these occasions. And he is speaking, as always, all speakers had to speak with wampum in their hand. So he's got a string of wampum, and he enters into this ceremony of condolence. With this string of wampum, I do, on behalf of His Majesty and all his subjects, wipe away the tears from your eyes. And he lays down the wampum, picks up another string. With this string, it goes on, I haven't given you all the quote, I do, on behalf of His Majesty, clear your throat, which is blocked from grief, so that you may speak freely again. Lays down that wampum, picks up another string. I do, with this wampum, clear your ears, which are blocked, so that you may hear again. And each of these are metaphorical statements of condolence to relieve the other party of any obstacle that would get in the way, whether it's anger, grief, or whatever, from engaging with the other on terms of equality and respect. It's the kind of good mind, as Mohawk people often describe it, essential to establishing relationships of spiritual kinship, relationships of brotherhood, and the kinds of respect and peace and tolerance that goes along with that relationship. I won't go through all of his statements here, but I did want to refer to this one. Having performed the ceremony of condolence, Sir William says, and as proof of the regard we have for the customs of our ancestors, etc., it is now time, he says, to further strengthen the union between us. And with that view, I do therefore with this belt, so he's got now, it's not a string, but a belt of wampum, in the name of your father. Again, it's a shift from brethren to father, which is interesting, the great King of England, and in behalf of his American subjects, renew and confirm the covenant chain subsisting between us. And he goes on to describe the importance of keeping it polished, bright, free of rust. And then the transcript states that the covenant chain is given 15 rows with human figures at each end. So much as the belt that Desquea was holding, a similar belt to that, I assume. I just very quickly wanted to mention an important treaty council held at Niagara in 1764. 1764 was the year after France ceded Canada to Britain. So the British have just defeated the French, and they acquire a clear title from the European perspective, that's important, to what became Canada. That whole territory around the Great Lakes in the map that I showed earlier. For the first time, the British Crown has, again, from the European perspective, a claim to the sovereignty. That doesn't mean they have sovereignty over the Indigenous peoples. And this Treaty Council at Niagara in the following year is designed to establish or affirm the covenant chain relationship with all of the nations, not just Haudenosaunee, but Anishinaabe as well. Again, a different linguistic and cultural set of communities. Some 2,000 representatives from all around the Great Lakes came to Niagara for that purpose. That's a picture of the French fort. And here's the same building today, or more recently. We're standing here on the Canadian side. So that's the American side. It's not at Niagara Falls, it's where the Niagara River enters Lake Ontario, where Niagara on the Lake is, if you're familiar with that town on the Canadian side. After weeks and weeks of discussions, Sir William crosses the river to what is now the Canadian side to meet with mainly Anishinaabe groups to renew and strengthen their engagements. And he says at this point, now it only remains for us to exchange the great belt of the covenant chain. And he gives a great covenant chain belt, 23 rows broad, in the year 1764 worked upon it. And oddly enough, you don't often see this in Treaty Council records. The price, the value is given 30 pounds, which probably was quite a lot of money in 1764. So these are the belts given. The top one is the one he's referring to, the 1764 belt. These belts have been lost, sadly, but drawings of them were made in the mid-19th century. The second belt was given at a different point at Niagara, and it's more clearly a covenant chain belt in the sense that it captures the oral tradition behind the covenant chain, which is that when the first European ship arrived on the river, the Indigenous Mohawk people, and it was probably a Dutch ship, attached a grass rope to it and tied that rope to a mountain. Later, they exchanged the grass rope for an iron chain. And then when the British took over the European end of the covenant chain in 1664, it was exchanged for a silver chain. So the covenant chain is a silver chain that needs to be polished and kept bright. So you get the ship and the mountain and the 24 people representing 24 nations that were at Niagara. Just very quickly, as I said, the lawyers for the government in this case that I was involved with said that's not a treaty. They denied that the covenant chain was a treaty relationship at all. So they said treaties are things like the one that I showed earlier that have a text that's written and signed. There were written treaty documents at Niagara, but only with a few nations in order to establish the end of hostilities and peace. But even these texts are really hard to understand without understanding the Indigenous legal traditions. So they're signed, you see, I don't know if you can, but William Johnson is signing on behalf of the Crown, but the Indigenous chiefs are signing on behalf of their clans, and they draw figures of their clan, wolf, bear, crane, etc. And in the oral transcripts for this treaty document, we find reference to the clan mothers installing chiefs and giving them authority to enter into the treaty. And Haudenosaunee law is based upon a matrilineal clan system and a matriarchal system of governance, where female elders invest chiefs with authority to engage in business and can withdraw that authority as well. And so it's important to understand that in order to understand what this treaty is doing. It's affirming Indigenous laws and systems of governance in a way. And so you see on treaty documents through over 100 years of examples of clan governance being affirmed through, among other things, the drawings of clan emblems. In the end, that particular peace treaty at Niagara only makes sense if you understand the unwritten covenant chain, because the written text simply says the covenant or old agreement between the English and them shall be the basis of this treaty. So that the treaty is just affirming the historic unwritten covenant chain. And during the negotiations, as I said, the women were clothing the chiefs with power, and 3 belts of the covenant chain were given. I'm looking at the time. I want to say a few more words about Indigenous legal traditions, and I think I can do that and wrap up fairly quickly by returning to that case that I mentioned earlier and telling you a little bit about the outcome. Just a few more things, and I found this difficult when I was testifying. I hadn't realized in the Quebec courts, witnesses stand. And so I was standing for 3 days. It was actually an exhausting experience. And actually, I have thought back on that experience. I'm not sure I would want to do it again. It was in many ways a lot more stressful than defending my doctoral thesis, because I was cross-examined by experienced counsel from both the Quebec and federal governments, and they would not let go of this idea that it's not a treaty, and it's difficult to explain a treaty which needs to be understood from an Indigenous perspective, especially as I'm not an Indigenous person. But I gave this example in court just to give a sense of the flavor of this relationship. It's an old transcript from the 1685, so just after the British took over the covenant chain, the European end. And the transcript reads that an unnamed Mohawk orator said the following: "Where shall I seek the chain of peace? Where shall I find it but upon our path? And whither doth our path lead us but into this house? This is a house of peace." After this, he sang all the links of the chain over. So this is a statement made and then sung in the Mohawk language. It's being translated, and then somebody else is doing their best to write down what is being said. So there are layers of translation and interpretation. And we don't know exactly what the song was, but the mere fact that you can sing the treaty is important in my view. It is a kind of relationship which has a spiritual quality to it that can be captured in traditional song. And you see this reference to singing the covenant chain in other documents as well. They sing a song after their manner, being their method of making a new covenant. So how do we capture the meaning of this treaty relationship without trying to appreciate the Haudenosaunee perspective? Europeans did write about Indigenous traditions. Lafouteau is one of those French writers, missionary, who tried to capture what he understood to be the system of government, the matrilineal clans and clan governance. He called it, this is an English translation, but a government based on woman's rule. The people, Haudenosaunee people, that translation, Haudenosaunee, is people of the Longhouse. They lived in longhouses, and the matrilineal clan or clan segments, the families related to an elder female would cohabit. Men would, husbands that is, would retain their own matrilineally defined clan identities and maybe live with wives, but it was a matrilocal kind of arrangement. And the Longhouse came to symbolize the whole Confederacy. So I've mentioned the clan identities being important and the female elders selecting clan chiefs. It's a legal system that looks very different from European systems. We think of, in a very simplistic terms, a European nation state has a sovereign. It issues commands as law to individual subjects. Different states internally have this structure. And between them, between states, is a law of nations or international law. So it's a bifurcation of domestic and international law. In Indigenous legal traditions, there isn't that same bifurcation. It's more of a circular expansion of relationships from the core, the clan, and the clan relations within a village, the village having a council of clan chiefs. And those village chiefs would then meet with other villages in their nation. And those national chiefs then would meet in a confederal council of nations, each layer involving the extension of ties of spiritual kinship. And the Haudenosaunee Confederacy is represented by this wampum circle, strings, 50 of them representing the 50 confederal hereditary chiefs of the Confederacy. Efforts to write down the Great Law of Peace, which is the constitution of the Haudenosaunee people, began in the late 19th century. And there are various versions of of the Great Law, as it's called. They're based upon origin stories that involve a sky woman falling to a flooded earth and being rescued on the back of a turtle. Earth diver mythologies or stories are common within the Great Lakes region and usually involve a small animal diving for earth and bringing it to the surface, out of which the earth was formed, and people and animals were then able to coexist. Recognizing animals as having a kind of spiritual identity and being, and councils, so the animals themselves being capable of holding councils and exerting a jurisdiction was important. So human jurisdictions are introduced into a world already populated by a series of shifting and dynamic spiritual and animal jurisdictions. The goal for this kind of governance is to seek a form of harmony with the natural world, with the spiritually charged natural world, the spirits of animals and of the waters and the sky. Gift giving is essential to establishing that kinship, both with animals and other peoples. And hence the importance of clan identities, which are traced to animal spirits who form the origins of the clan. So how do you write all that down? With great difficulty, but attempts have been made beginning in the early 20th century to reduce the Great Law of Peace to a form of written law. In this particular version from 1912, put together by this Chief Seth Newhouse, there is an interesting moment. The law is based upon an epic story of a peacemaker who travels to bring the story of peace to the warring Five Nations. And the critical moment, it seems, in this story is when the peacemaker convinces Hiawatha to join him. But in order to do that, this important chief, Hiawatha, has to be condoled. Back to that ceremony of condolence that is central to the treaty relationship. This says a lot, I think, about what legal ideas are behind that ceremony. It's at this point that, by legend, the power of wampum is discovered, and Hiawatha and his grieving mind, he's grieving about the death of his daughters from the violence that has occurred, is condoled, and the peacemaker uses the wampum to clear his eyes, throat, and ears so that he can think rationally again. And according to this version, the peacemaker says, "Your mind being cleared and you being competent to judge, we now shall make our laws." And they proceed to establish the Confederacy. Why I think this is important is I think something's going on like this when Sir William Johnson performs the very same condolence ceremony. He's establishing the grounds for a legal relationship or a rule of law. Back to this idea of legality and the rule of law. It's a cross-cultural one that is shaped by adherence to Indigenous legal tradition that allows for rational thought and the building of a relationship of trust and care between autonomous nations. This is a picture of Hiawatha and the great peacemaker bringing peace to the Six Nations. And there's the Hiawatha belt, the symbol of the Haudenosaunee Confederacy today. I'm going to wrap up now. This is a long quote, and I'm not going to read it all. I mentioned the Treaty of Niagara in 1764. What status legally did the Indigenous partners to that relationship have. In this long quote, which I won't read, Sir William Johnson says, he has heard of a treaty made by another representative that purports to call the Indigenous peoples subjects. And he proceeds to explain, that cannot be. I just made a treaty with them at Niagara, he says, and I'm convinced that they never mean or intend anything like this idea of subjection, and that they cannot be brought under our laws for some centuries. Then further down, some attempts towards sovereignty over them were attempted not long ago, and this was the principal cause of our trouble. So the covenant chain is not an assertion of sovereignty. It's somehow a recognition of a degree of unity and independence together in a kind of relationship of trust. Okay, I'm going to end there, but I should let you know the outcome of this case. Well, Montour and White were acquitted by the judge. There was no jury. It was not a jury trial. The judge, Sophie Bork, accepted the relationship of the treaty, the Covenant Chain Treaty, as a treaty protected by Section 35 today. She did not rule as to the specific rights of self-government that the Mohawk and other Haudenosaunee enjoy under this treaty. Rather, she said, it was inappropriate to proceed with criminal charges against the accused in a context in which the governments of Canada and Quebec had failed to engage in a respectful dialogue as to the meaning of the treaties. And therefore, in effect, she was saying, in absence of that respectful dialogue, which the covenant chain requires, prosecuting these individuals would be inappropriate. So a remarkable decision with far-reaching consequences for Canadian constitutional law. The attorneys general of Quebec and Canada have appealed. It will go to the Quebec Court of Appeal, and we don't know how the arguments will be received. But there is, I think, an indication that the judges in Canada are increasingly concerned about ensuring that the treaty relationship is one that is treated with respect and meaning. So I'm going to stop my presentation there, and I hope you've enjoyed and learned something from it. I should say, if anyone watching this has questions to ask, you can always find my email address on the Queen's University website, Faculty of Law, and you can find me, and I'd be happy to answer any questions that you have. So thank you very much.